Welcome to the I Got Fired podcast. I'm Tom Spiegel, founder of the Spiegel Law Firm, where we help people who have been fired or afraid that they might be. Today, this is the second in our series on mediation. We're going to be talking about mediation before an administrative body and an employment law that is often before the Equal Employment Opportunity Commission, or EEOC. But before we begin, a little bit of legalese here. Remember, this is not intended to be specific legal advice for you in your case. This is for educational purposes. If you want legal advice, then you got it. You should go hire a lawyer. All right, so let's get started. So in the last episode, we talked about the general outlines of mediation, which are pretty much the same across all types of mediation. So if you want the general, how is this going to work, then listen to that first episode. Today, I want to talk about mediation before an administrative body. And by an administrative body, I mean there are a number of government agencies, both state and federal, that have jurisdiction over employment law claims. And in many instances, depending on what kind of claim you have or what happened, you have to file what's called a charge with an administrative body. Often it is with the EEOC. So, for example, if it's a discrimination case, if it's a sexual harassment case, disability discrimination, you're going to have to file before one of these administrative bodies before you can file in court. And failure to do so may mean you lose your right to bring your case at all. So it's really important. And when I say administrative bodies, that's, I use, I don't want to say just the EEOC, because it's possible that you could have your claim filed with the state or local agency. For example, if you are in Arlington, Virginia, or Alexandria, Virginia, or a number of Northern Virginia counties, there are going to be local, basically human rights offices. They're called different things, but essentially offices of human rights that you can file your claim with. And they have what's called work share agreements with the EEOC. So they can do things called cross-file, which essentially means you can go file in your state agency, and they will also file for you at the EEOC. If you're in DC, there's the DC Office of Human Rights. You can file there. And again, it's the same as if you file before the EEOC. And there are reasons for filing with those state agencies rather than the EEOC, particularly if you are also going to raise state or local claims. For example, the DC Office, the DC Human Rights Act, which the DC Office of Human Rights oversees, has some claims that are much broader than the EEOC. So you might want to file them at that state level, because there you can file both the state claims and the federal claims. In a lot of cases, the federal claims are better claims anyway, so you're going to end up filing at the EEOC. Not true for all employment cases. For example, like wage and hour cases, Equal Pay Act cases, that you can file those with the EEOC, but not required. Other employment cases, if you're being sued for non-compete, you're not going to have the option of filing at the EEOC. But a good many are going to end up before the EEOC, which is a specific type of administrative body. So at the EEOC on the federal level, mediation is a possibility. It is not required. So both you and your employer have to agree to mediation. In some other agencies, for instance, if you file with the DC Office of Human Rights, mediation is mandatory, so you don't get a choice. Both sides get to have to participate in this mediation. So mediation before these administrative bodies, this is probably the least effective forum to mediate. And the reason for that is, there are a couple. First is, there are many great people who work at these agencies and who take mediation very seriously. There are many who do not, and they are not well-trained mediators. They've got a bunch of other files on their desk. It's not so much that they're going to just go through the motions, but they're not going to push in the same way that as a judge would, or certainly as a private mediator. They're working their 9 to 5. Your case settles. Yes, yes, no, no, and they often, either because they don't have time or because they're not that interested, they're not going to know a lot about your case when you walk in the room. So they're going to sit down. They may have a page or two about your case, and that's gonna be it. The other reason that it's not terribly effective is for many companies, if this claim is going to be covered by insurance, and there's no way at this stage for you to know whether it will or if it won't. There's nothing you can do to affect that. That's just something that exists with your employer, or it doesn't. The insurance adjusters may or may not get involved at the EEOC level. So even if they do mediation, they're going to send somebody who's fairly low level, who may not even have what we call settlement authority. Essentially, they're not bringing the checkbook. They don't even have authority to settle the case. They're just there to, kind of punch a clock. So you could have an ineffective mediator. You could have a disinterested or ineffective person on the other side who does need to have settlement authority, which makes it of little use to anybody. That said, I certainly have had cases that we've settled at the administrative level, so that it does happen. You can get cases settled. I had at least one case that I can remember where we settled it for over 6 figures. But that tends to be the rarity. It tends to settle for lower dollars at this stage, unless you've got a really, really strong case. So that's one thing to consider going in. As I discussed last time, this is true for all mediation. You need to know what your parameters are, like what is going to be success for you at the end of this mediation. You're much more likely to settle a case at the EEOC level if you're asking for $20 than if you're asking for $100,000. So, even if the chances of settlement are low in terms of somebody writing you a check or getting it done, there are some other benefits. As we discussed in the last episode, you're going to learn something about the other side. You may get to meet their attorney for the first time. You may hear, what their defense is going to be to the case. You may get a sense of who the personalities are, which can be helpful. And of course, the other side is doing the same thing. They want to see what you're like. They're kind of, checking the lay of the land out as well. So you're going to learn going through that process. But here are a couple of tips when you're dealing with an administrative body. And let me say, as is true for all mediation, don't assume that they know much about your case. I mean, you've been living with this, for months, but perhaps years. Every twist and turn in the case. You likely know every email. You've been living this. And this mediator, when they walk in the room, they may have looked at your file 5 minutes before they walked in. So they know only the bare bones. So if this is not a place to hold back your key evidence and try to ambush folks. That's really rarely is possible in civil litigation in any event. But if you've got a smoking gun piece of evidence and you want to show it to the mediator, so that they really get behind your case and want to help you out. One of the positive things about going to the EEOC, if you do settle it, tends to be very employer friendly. The agreement that they usually draw up isn't as one-sided in favor of the employer, which can happen in other kinds of forum. Like here, the mediator is, again, the EEOC's charge is to be employee friendly. It doesn't often live up to that, but when it comes to settlement, they usually are pretty good about that. Okay, so a couple of tips about how to make this successful, and this is true whether you're doing the mediation or you're going through an attorney. The first is, before you go to that mediation, let's assume both sides agree to it, or again, you may be in a jurisdiction or in a forum where it's required. Contact the other side, or make sure your attorney has contacted the other side to find out if they're going to send somebody with settlement authority. They should be able to tell you that. And the EEOC asks for both sides to have settlement authority, but they're fairly toothless, and so sometimes you'll have employers in particular that won't. They'll send somebody from HR just essentially be a potted plant, and so there's no chance you're going to get it resolved. So you want to talk to the other side and say, hey, look, are you bringing somebody with settlement authority? If they say no, then you might want to consider whether or not this is worth your effort, particularly if you've got an attorney and you're paying for that attorney by the hour, and your attorney should be having this conversation with the other side and with you. But let's assume that that they're bringing somebody with settlement authority, then you want to bring your evidence. At the EEOC, you definitely want to bring your snacks or whatever it is that you need. You're probably going to be in a windowless conference room. If the mediation is at all productive, it's going to go for at least a couple hours. It can certainly go for more. And you may not even be able to get to a vending machine. So, bring in the, food, drinks, whatever it is that you need to get through it, because nothing's worse than getting in, knee deep in a mediation and you're hangry because you had breakfast 6 hours ago and you need a cup of coffee and a donut or something. So, to the extent that you can, stick that stuff in your purse. And at the EEOC, most places, they will let you bring that in. Again, you may have some breaks and you may be able to get to a vending machine, but be prepared that you may not stick a couple energy bars in your purse or your backpack for when you come in. So you've got your snacks, you've got your key piece of evidence. If the other side, and hopefully they do, they're bringing somebody with settlement authority, and what your number is. Like, what are you willing to walk out of there? What would be success for you? Understanding that if you're coming in at a high dollar mark, you're probably not getting it done at the EEOC. Never say never, but you're probably not getting it done at the EEOC level. So that is, how it works at these administrative bodies. Again, and let me say another thing about, being before the, one of these government agencies is typically there will have been no what we call discovery done. So if you're in litigation, both sides can send written questions to the other side, and you have to answer them. It's a compulsory process. You've got to answer these questions. Both sides do. There can be, of course, depositions where they take testimony under oath before a court reporter, which happens in civil litigation if the case goes any distance. But at the EEOC level or an administrative level, that's not going to have happened yet. There's going to have been no discovery. So you're not, if there's a smoking gun document that the other side has, deep in one of their computers that you might be able to get to with some discovery, you're not going to have that at the EEOC level, which is another reason why cases are less likely to settle there, because it just hasn't been developed. So, it's worth doing generally. You want to talk with your lawyer. You want to talk with the other side. You want to consider, whether it's a good use of your time. But if you follow the tips that I just talked to you about, it can be productive whether or not you end up with a signed settlement agreement at the end. So I had a thought and now it escaped me. So those are the reasons to do mediation at the EEOC process. It can be productive even if you don't settle. Some cases do settle. Oh, I know what I was going to say. Particularly because these happen early in a case, this is an instance where, it's certainly possible to handle a case on your own through the demand letter stage. I'm biased. I think it's better if you have a lawyer, but you can certainly do it on your own. You can file a charge at the EEOC on your own. It's not particularly difficult. Again, you're going to be more sure to touch all the bases if you have a lawyer, but it's not rocket science. You can figure it out and you can file a charge. I think once you get to the mediation stage, this is a place where it makes sense to hire a lawyer, even if it's just for that one-time push. And lawyers do this all the time. You can hire somebody to say, hey, I just want you to represent me in mediation. Some lawyers will do it on contingency. Some lawyers will do it hourly. You can listen to our other podcast on how to pay for or fund your employment law case. But you can hire a lawyer just to represent you at the mediation, and you're more likely to get that case settled if you have a lawyer there, particularly if the other side has a lawyer. So just as a matter of strategy, if you've been handling the case on your own to this point, I would strongly encourage you to hire a lawyer, even if it's only to appear with you at the mediation. The one caveat to that where I might say it makes sense for you to do it on your own as opposed to hiring a lawyer is if you know the personalities on the other side and you've made a judgment that you think you can speak to them in a way that if you had a lawyer would be problematic. I mean, obviously, if you bring a lawyer, it kind of ups the pressure a little bit. Often that's a good thing. There are times when upping the pressure can make it less likely for you to settle. More likely you're going to push your employer into a corner. Again, a judgment call, but you may know the personalities here. If it's a big Fortune 500 company, they're going to send somebody that you likely have never seen before. They don't know you, you don't know them. It's probably helpful to have a lawyer in that situation because it's not you're going to be able to trade on any goodwill. But if it's a smaller company, or if let's say it's larger and that somebody from HR is coming, or the general counsel or somebody at the company that obviously you filed a charge at this point. Things aren't all chummy between you and your former employer, but I have seen where employees can go and talk to a former employer, particularly if they have a good history with the people involved, and just sit down and say, look, this is sort of where I am with this. I'm not trying to throw bombs here. I know you guys are good people. I just think this is, wrong. That was what happened to me. I know you have a job to do, but I'd really like to, try to get this settled. Whatever. Yeah, I'm not trying to put words in your mouth. You know what the situation is, but you're like, hey, Bob, I've worked with you for 20 years. We have a good history together. Let's see if we can get this done. And then going back to when I talked about in the first podcast, the first episode in the series on mediation, you want to think about, if you're going to make an opening statement, what that's going to look like. Because if you know the parties on the other side, you might want to take, if not even a softer, if not conciliatory approach. You want to appeal to their good nature, to their history with you, because you want their goodwill to get this case settled. So in those instances, tend to be fairly rare, but certainly not unheard of. In those instances, you may want to handle it on your own. Look, you could hire a lawyer to advise you behind the scenes, to talk to you about your case before you go in. They just don't have to come with you. That could be a really good way to handle this, because that way you make sure all your ducks in a row, that you're not leaving off any important claims, that you are not really undervaluing your case. So that's a possibility. But regardless, that could be a situation where having a lawyer could be detrimental. Get a judgment call that you'll have to make. In most instances, I think it's really helpful to have one. Whether the case gets resolved or not, it's likely to be more productive if you have an attorney with you by your side, even if it's only for that mediation. Then after that, you're going to continue to handle the matter on your own. If cases don't resolve at the administrative stage, then usually what happens is the case goes on into investigation. I'm going to put that in a little bit of air quotes, investigation, because particularly at the EEOC, they are understaffed, underpaid. They've got a lot. The investigation they do is usually pretty cursory. So don't get your hopes up that they're going to really go out there and beat the bushes for you, because they're probably not going to. On the state level, it tends to vary a little bit more. You can get some folks who have a little bit more time, maybe a little bit less jaded about it, who will really put their shoulder behind the wheel to try to get the case investigated. But regardless, what's going to happen if mediation fails is it's going to go on to the investigation stage, and then in all likelihood, you're going to get something that's called a right to sue, which is what you will need to be able to file your case in court. There are very small instances where the EEOC will take up the case on its own, but the chances of that happening are slightly better than getting struck by lightning, but not much better. So anyway, that's for another day. I hope you found that helpful. If you'd like to certainly support the podcast, leave us a review. It's really helpful. Or subscribe to the podcast. You'll get all these episodes. And if you would like to follow me on LinkedIn, I post there often about employment law and other matters, and I look forward to seeing you there. And good luck in your mediation.